Hi, my name is John Festinger, and this is the video blog for News of the Week, October 22, 2014, in association with the video game law course at the University of British Columbia's Faculty of Law. This week, contract law, specifically end-user license agreements, and a fascinating item which appears as the fourth item in News of the Week on the website. It's from TechDirt. Nintendo bricks Wii U consoles unless owners agree to new EULA. The facts apparently are pretty simple. If you don't agree to Nintendo's end-user license agreement, your Wii U will stop working. And there's no way around it, and there's no alternative, and there's no way of proceeding without agreeing, as has been the case in previous updates respecting other consoles. If you're not going to agree, you might not get all of the features, not everything might work, but your console will keep working. Not the case here. So it's a form of one-way, no choice, consumer adhesive contract. There's no way to say no unless you're willing to lose rights that you've already bargained for and paid for. The next item also appears under item 4. It's sort of the second part. It's a journal paper, an online journal paper called Virtual World Players, Consumers, or Citizens. And this sort of goes to the heart of the issue. And that is, what rights do we have? We all play differently. We all relate to our technology differently. And at the end of the day, contractual terms and contracts themselves with developers, with console makers, with publishers are very much a one-way street and don't give us as gamers the rights that we might expect. And of course, the Nintendo example is just an extreme example of what a one-way street it is. So we're getting to a place of serious academic scrutiny in the area, and hopefully some common sense scrutiny. A couple of, I think, obvious questions. If publishers and video game companies and online companies are so keen to have individual profiles of us and market to us individually, why can't we have our own contractual terms? That hardly seems impossible. The technology obviously exists to do that. Yet we have a version of one flavor fits all. It's really take it or leave it contracts. On the other hand, the very peculiar thing is that the industry has not come up with a way of having a standard form end-user license agreement and maybe just notifying gamers what's different in theirs. And hopefully an industry association might work this through. At the end of the day, my suspicion is that if this doesn't get worked through in a realistic way, there may be consumer protection types of actions taken by government because, again, the Nintendo example is an extreme one, but it's a very, very odd situation. So to add to this, we'll come to just a final point, which perhaps brings it home. The first item under News of the Week is an Ars Technica article Judge says EA executives committed puffery, not securities fraud. So this was about statements made in various forums about Battlefield 4, an EA game, and a securities class action saying that what was said was tantamount to securities fraud. Court said no. And of course, contract law and securities law are vastly different. Yet we still have this odd specter where consumers, gamers, users are held to what they agree to, even though we all know, we aren't reading those end-user license agreements. We're just clicking I agree. And executives on the other side of the ledger are not being held to things that they've said in open forums. So imbalance, or just the result of very different laws? You decide. Thanks for joining me today. See you next week.